Good morning, everyone. My name is Siddhi Khanna. I'm assistant professor of IIMT College, Greater Noida. Today, I'm going to discuss with a topic named Privity of Contract and Privity of Consideration in the Indian Contract Act. Uh, okay, let's start. Introduction से start करते हैं कि डॉक्ट्रिन आप क्या बात करती है, प्रिविटी ऑफ कॉन्ट्रैक्ट है क्या, प्रिविटी ऑफ कंसिडरेशन क्या है. Doctrine of privity of contracting, a long-lasting principle in both English and Indian contract law, has faced criticism for its rigid stance on who can enforce a contract. Originally, this doctrine dictated that only parties to a contract had the right to sue each other to enforce its term, effectively barring third party from pursuing claim. However, as a legal landscape has evolved, exceptions to this doctrine has emerged, allowing third party to enforce contract under specific circumstances. This post explore the doctrine of privity of contract, its historical development, and the exceptions that have been established to strike a balance between legal rigidity and fairness in contractual relationship. ओके, तो हम आज क्या पढ़ने वाले हैं कि डॉक्ट्रिन ऑफ प्रिविटी ऑफ कॉन्ट्रैक्ट क्या बात करती है. दैट इज कि प्रिविटी ऑफ कॉन्ट्रैक्ट, पहले थोड़ा सा हिस्टोरिकल प्रोस्पेक्टिव भी देख लेते हैं इसका क्या है. द डॉक्ट्रिन ऑफ प्रिविटी ऑफ कॉन्ट्रैक्ट डीपली रूटेड इन इंग्लिश कॉमन लॉ, establishing the principle that only the parties directly involved in contract had the legal standing to enforce its terms. Okay. इसमें आपका एक पहला केस है जो इस डॉक्ट्रिन को एस्टैब्लिश करता है, दैट इज ट्विडल वर्सेस एटकिंसन का केस. The doctrine rigidly was evident in the case of Twiddle versus Atkinson, where Twiddle's father-in-law and Atkinson entered into a contract to provide financial support for Twiddle and his wife. After Atkinson's death, without fulfilling his obligation, Twiddles attempted to sue Atkinson's state for breach. Okay. However, the court denied his claim, emphasizing the absence of consideration for Twiddle's fathers-in-law to Atkinson and the fact that Twiddle was not a party to the contract. This case set a precedent for the strict application of privity of contract. Okay. तो ये केस बहुत ही ज्यादा इंपॉर्टेंट है, जो प्रिविटी ऑफ कॉन्ट्रैक्ट का पहला लैंडमार्क जजमेंट था, ट्विडल वर्सेस एटकिंसन. Next case is Dunlop Pneumatic Tire Company Limited versus Selfridge and Company. 1915 का केस है. That is the doctrine of privity began to evolve in the case of Dunlop Pneumatic Tire Company Limited and Selfridge and Company. This is a landmark judgment that marked the departure from its rigid application, in which आप थोड़ा सा इसके facts भी देख लीजिए. That is a tire manufacturer company रहती है, that is the pneumatic tire company, enter into an agreement with his dealer, including due income, to maintain a resale price for its production. Resale price sale agreement कहते हैं इसको. इसमें क्या होता है कि दो कंपनीज हैं, उन्होंने आपस में ऐसा कॉन्ट्रैक्ट किया कि आप मेरे प्रोडक्ट को इस पर्टिकुलर प्राइस से नीचे सेल नहीं कर सकते हैं. इस तरह का अग्रीमेंट दो पार्टीज के बीच होता है, इसको कहते हैं रीसेल प्राइस सेल एग्रीमेंट. तो ऐसे ही कुछ कॉन्ट्रैक्ट डनप न्यूमैटिक टायर एंड सेल्फ्रिज एंड कंपनी के बीच हुआ था, जिसमें डनप also required dealer to obtain similar undertaking from their retailer, including Selfridge. When Selfridge sold tire below the agreed price, Dunlop sue for breach of contract. Okay. Then appeal lies. On appeal, Selfridge argue that Dunlop could not enforce the contract's burden against it because it had not consented to the contract between Dunlop and Dale. तो कोर्ट की क्या रूलिंग आई? The court ruled in favor of Selfridge, emphasizing the suffrage was neither a principal nor an agent, and therefore was not bound by the contract between donor and due. This case hinted at exceptions to privity, ban justice and equity demanded. Okay. Then प्रिविटी ऑफ कॉन्ट्रैक्ट का इंडिया में क्या एप्लीकेशन है? क्या यहाँ पे प्रिविटी ऑफ कॉन्ट्रैक्ट एप्लीकेबल होता है या नहीं होता है, इसके रिगार्डिंग हम आगे देखेंगे. तो when we talk about Indian Contract Act 1872, Indian contract law initially mirror English law's strict adherence to the doctrine of privity of contract. It firmly asserted that only parties directly involved in the contract could enforce its terms. The Privy Council decision in Jamuna Das versus Ram Avatar reaffirmed this principle, amplifying the strict application of privity. Okay. Then we have to discuss the case law Jamuna Das versus Ram Avatar. Stricter application in India. इस केस में ये बताया गया है कि प्रिविटी ऑफ कॉन्ट्रैक्ट इंडियन लॉ में कैसे स्ट्रिक्टली फॉलो किया जाता है, स्ट्रिक्टली एप्लीकेबल है. इन दिस केस कुछ फैक्ट्स हैं यहाँ पे, आप देख लीजिए. इन दिस केस अ बोरोड मनी बाय मॉर्गेजिंग द प्रॉपर्टी टू बी एंड सब्सिक्वेंटली सोल्ड द प्रॉपर्टी टू सी. जनरली क्या होता है, मॉर्गेज में ऐसे ही होता है, with the intent to redeem the mortgage if needed. Okay, when B sue C for the recovery of mortgage money, C's defense rely on the privity of contract. The Privy Council rule in favor of B, asserting that C, the purchaser, had entered into no contract with B and therefore was not personally obliged to pay the mortgage debt. This case exemplified the strict adherence to the privity of contract doctrine in Indian law. Okay, तो ये आपका केस बहुत इंपॉर्टेंट है, जमुना दास वर्सेस राम अवतार का. नाउ अब हम आगे बढ़ते हैं, जिसमें कुछ एक्सेप्शंस के बारे में बात करते हैं कि प्रिविटी ऑफ कॉन्ट्रैक्ट का एक्सेप्शंस इंडियन कॉन्ट्रैक्ट एक्ट में क्या है. That is exceptions to the doctrine of privity of contract. Recognizing the injustice that could result from the strict application of the doctrine, exceptions have evolved in both English and Indian contract. Okay. These exceptions ensure that third parties are not left without legal recourse when fairness and justice demanded their involvement. So, पहला आपका है, that is beneficiary under a contract. So, पहला exception है beneficiary under a contract. One of the most significant exceptions to the privity of contract is the recognition of beneficiary under a contract. When a contract explicitly intended to benefit a third party who is not a signatory to the contract, the third party may enforce the contract's provision. This exceptions align with the intention of the contract parties and ensure that beneficiaries are not left without legal recourse. एक एग्जाम्पल से समझते हैं. If a party A and party B enter into a contract explicitly stating it benefits party C, who is not a party to the contract, party C has a legal standing to initiate legal proceeding to enforce the contract if either party A or party B fail to fulfill their contractual obligation. Okay, these exceptions promote fairness and uphold the underlying purpose of the contract. Understand? Next, exceptions आपका बात करता है, that is conduct, acknowledgement or admission. Another exceptions arises when one of the parties through their action, representations or acknowledgements recognizing the right of third party. In such case, third party may have a legal basis for bringing a claim based on the principle of promissory estoppel. Okay, these exceptions emphasize the importance of honoring promises and assurance made by the parties, even if a third party is not a direct party to the contract. It prevents party from re-engaging on their commitment when a third party has reasonably rely on those commitments to their determination. For instance, if party A enter into a contract with party B and subsequently represent to party C, that party C will also benefit from the contract. Party C may have a valid legal claim against party A for breach of promise if party failed to fulfill the representation. Okay. Next exceptions is provision for maintenance and or marriages. Contract that include provision related to maintenance or marriage represented exceptions to the doctrine of privity of contract. Under these circumstances, third party is not directly involved in the contract, but have a vested interest in its performance may enforce the contract. Okay, the underlying that is vested interest. अब एक एग्जाम्पल से समझते हैं. If party A promised to provide financial support to party B for their lifetime with the condition that, with condition क्या है, that party C also receive a specified amount. Party C can initiate legal proceeding against party A if party A breach the agreement. This exception recognizes that certain contracts have far-reaching consequences beyond the immediate parties involved and seek to protect the interest of those indirectly affected by the contract. Okay. Next आते हैं exceptions पे, that is from family settlement. If a family agreement stipulate that 3 sons will each contribute a specific amount to daughter's financial security and 1 son failed to fulfill his obligation, okay, the daughter may have a valid legal claim against the defaulting son. This exception upholds the principle of fairness and family intention with the context of contractual relationship. Contract created as part of family settlement may permit third party to enforce the contract if they are intended beneficiary. Family settlement often involve complex arrangement designed to benefit various family members, and enforcing such contract aligned with the family intention and equitable consideration. Next exception is estoppel. So promissory estoppel principles provide another basis for third party to seek relief against a promisor. To establish a claim based on promissory estoppel, the third party must demonstrate elements such as clear promise, reasonable reliance on that promise, and determine offense due to reliance. This exception underscores the significance of maintaining the integrity of promises and ensuring that parties are held accountable for the commitments even when their parties are involved. इसको एग्जाम्पल से समझते हैं. For example, if party A make a clear promise to party B that party C will receive a specific sum of money and party B reasonably rely on the promise to the determinant, then party C have a valid legal claim against party A for promissory estoppel. Okay. So हमारा प्रिविटी ऑफ कॉन्ट्रैक्ट का जो पार्ट था वो यहाँ पे एंड होता है. नेक्स्ट वी वर टॉकिंग अबाउट प्रिविटी ऑफ कंसिडरेशन. जनरली क्या होता है कि प्रिविटी ऑफ कॉन्ट्रैक्ट, प्रिविटी ऑफ कंसिडरेशन को एक जैसा समझ लिया जाता है, दोनों कॉन्सेप्ट अलग अलग हैं. सो जब भी आप प्रिविटी ऑफ कॉन्ट्रैक्ट पढ़ें तो प्रिविटी ऑफ कंसिडरेशन को साथ में पढ़ें. सो द प्रिविटी ऑफ कंसिडरेशन क्या होता है? That is, it is necessary to distinguish the Indian rule that prohibit stranger for filing lawsuit from the stranger to contract rule. The Indian Contract Act 1872 stated that consideration can be given by either the promisee or a third party. This does not, however, change the rule of privity of contract. So, यहाँ पे important बात बताई गई है, privity of consideration अलग terminology है and privity of contract अलग terminology. So the principle is that an individual may not have received any consideration for himself, but he can still enforce the term of agreement if he is party to it. The promisee or any other person may provide consideration as per the Indian Contract Act. It implies that it doesn't matter who provide the commitment as long as there is consideration for it. It can come from the promisee or in the event that the promisor is unopposed from anybody else. However, English law has a different stance. The promisee himself must no longer be the primary focus there. As an illustration, suppose A agreed to give B his watch in exchange of payment of rupees 5,000, which is made to A by C rather than by B. In England, this contract will not be enforceable, but in India, things are different because Section 2H explicitly stipulates that consideration may be given at the promisor request by the promisee or by anybody else. Privity of consideration आगे इसमें है, that is this idea is further explained in the Chinagya versus Ramaiya case, जो बहुत important phrase है आपका privity of consideration में. In this case, an elderly woman left her wealth to her daughter with the condition that the daughter give A's brother, जो यहाँ पे आपका plaintiff है, an annuity of rupees 653. The defendant and the plaintiff agree that she would pay the annuity in accordance with A's instruction. The stipulated amount was not paid by the defendant. She argued that plaintiff had no consideration and therefore no right of action in lawsuit brought by the plaintiffs against her. But the Madras High Court ruled that the defendant's mother had provided sufficient consideration in this contract, which is required to uphold the plaintiffs and defendants' agreement. It is evident from this stance that although A and B engage into a contract, A does not personally supply any consideration to B. आपने देखा यहाँ पे A ने कोई consideration नहीं दिया है. Instead, B received consideration from a third party C. लेकिन B को consideration receive हुआ है third party से, that is C. A is unfamiliar with consideration, yet he can nevertheless hold B accountable for the term of the agreement. It is important to keep in mind that this only applies to Indian law. In English law, the situation is different and the consideration can only go from the promisee to the consideration. Foreigner can't under any circumstances go to the consideration. Okay. Next हम आते हैं, हमने कॉन्सेप्ट सारे देख लिए, अब कंक्लूजन पे आते हैं कि हमारा कंक्लूजन क्या निकलता है. Consideration is an essential feature for a valid contract, without which generally a contract is not enforceable in the court of law. Consideration has been defined in Section 2D of the Indian Contract Act 1872. Privity of contract is a legal rule which stated that only parties to a contract can sue for breach of for the breach of contract, and this right to sue does not extend to third party. However, the above principle is not well established in India and it's subject to a lot of debate and discussion among scholars and professionals. There have been Indian cases which have been discussed in the article where given circumstances, the rule of privity of contract was not applied. While in other cases of similar nature and circumstances, the rule of privity of contract is applied. The article also deals with the exceptions to the rule of privity of contract. So, हम लोगों ने exceptions पहले देख लिए. Also, the rule of privity of consideration is discussed briefly in this article. Unlike the rule of privity of contract, rule of privity of consideration is well established and clear with the statutory backing. It has been explicitly mentioned in the definition of consideration provided under Section 2D that the consideration can be furnished by any person. The judicial interpretation as well as legislative enactments have also been provided. Okay. Thank you. Uh, Thank you for watching this lecture.